Hi, I'm Shannon Miller with the Miller Elder Law Firm. I am here today to talk a little bit about potentially guardianship proceedings and also to discuss maybe your upcoming phone call with myself or with Jenna Fasulo Lapierre, who is an associate with our firm. And it's likely that you're listening to this video because you think that there may be the need for a guardianship or a guardian advocacy for one of your loved ones. So I'd like to talk to you a little bit about that process. And sometimes what we find is that after people have that initial call, it's so much information that sometimes going back and reviewing like this video might be helpful to you to kind of remember what were the important things during the call about guardianship or guardian advocacy. So we're going to talk guardian advocacy first. It's a very simple process. It usually involves someone who has a developmental disability that they've had either since birth or since a very young age. That can include Prader-Willi syndrome. There are some other autism, which we now talk about being on the spectrum. So some of those types of diagnoses are also included as developmental disabilities that would be that allow you to go through a guardian advocacy process for your loved one instead of full-on guardianship, which is great because it's like an abbreviated process, even though a lot of the same protections will still be in place, such as having an attorney appointed for our loved one going through that process. But they don't have to be examined by a doctor and two other mental health professionals. So it does end up being a lot less hard. So guardian advocacies can be set up by filing a petition with the court, having that attorney appointed, and then having some sort of medical testimony. Sometimes that's like a habilitation plan or some kind of IQ test that you might have from a school report. It's very kind of informal as far as what kind of medical testimony would be needed to allow for your loved one to go through a guardian advocacy process. The IQ test is usually 70, although the court has some flexibility to go up a little bit, like to 80. And really, when we're talking about individuals who have things like Prader-Willi syndrome or suffer from a spectrum disorder, then, and I shouldn't say suffer from, they have a spectrum disorder, they may qualify as well, even if their IQs are higher. So that is a little bit about guardian advocacy, and I've told you what the shortcuts are. Let's talk about guardianship. Guardianship is reserved for those who are incapacitated, but who need help with either managing their finances or managing their person. There are actually two different types of hats that the guardian would wear. One is that personal hat, and one is that financial hat. So we often talk about, there being two different guardians potentially. One would be guardian of the property and one would be guardian of the person. Putting on those different hats, sometimes the same person can wear both hats. And that's usually the case. So when a petition is filed, basically, usually that person is having some sorts of crisis moment where they need help with the guardianship. Either they're being exploited, that's very common. Sometimes we'll file an exploitation injunction to stop or eliminate the exploiter from continuing to unduly influence the victim. And we do an emergency guardianship at the same time. That can be heard by the court within 5 days. And now with the exploitation injunction statute, we can actually get a lot of help right away without even having the exploiter be notified, even if that exploiter is a family member. So what will happen sometimes is that victim, or what we call the alleged incapacitated person, or the AIP for short, will be in a crisis moment. Sometimes they've had a problem, a medical problem, and they're in a coma or they have dementia, and they've progressed to the point where they can no longer manage their own bills. Sometimes Adult Protective Services gets involved and finds out that this individual who is just not paying their bills or taking care of themselves properly. And so, sometimes we even get, contacted by Adult Protective Services or by a judge who says, hey, I need you to potentially step into this case to help this person in need. And so sometimes we take on those kinds of cases and try to, figure out where other family members might be who could serve as guardians and get things going for this person. So sometimes what happens is a person is in denial about their situation, and so we sometimes have family members who call us concerned about their loved one. You can hear our puppies are in the office today. It's something we really enjoy at the firm. Anyway, so I will usually get that phone call, and I will talk to you about what's going on. And is it an emergency? And in order for it to be an emergency, basically there has to be serious risk of harm either to the person physically or to their finances. So then we can get a quick turnaround. In most cases, that's not the situation. So we might file that petition to appoint someone to be appointed as their guardian, and at the same time we file a petition for incapacity. And the petition for incapacity has to allege grounds for why it is that we have these concerns. So usually some sort of facts. We need evidence to put in that petition. And then that petition gets filed with the court along with the petition to appoint the guardian. And then an attorney is appointed to represent the alleged incapacitated person. That attorney will go out and actually read those petitions to that person and find out, what is going on with the person. Do they need help? Are they willing to agree to the guardianship? Or what is going on? So, what can happen is that person may have drafted their own estate planning documents before we file the guardianship. So sometimes when I get that initial phone call, I will say well, if they have a power of attorney, maybe we can use that instead of doing a guardianship. Guardianships are very expensive. They're not fun for our person. And sometimes they can create a lot of discord in a family. You've heard probably in the news about, difficult situations involving guardianship proceedings. And sometimes it's just, having a court intervene in your family, in your family's life is a challenge. And so it can be very difficult and expensive. So we always try and do everything except guardianship, but sometimes there really aren't any options, especially when we have exploitation or when one family member has, isolated the person and is really becoming a difficult situation. Or sometimes we have people who think they're fine and they're not fine, and so they may be wandering or found in the neighborhood, or they may be really not taking care of themselves. So sometimes we have to intervene in those cases as well. And sometimes it's younger people. We might have somebody with mental health issues. Or we've had recently, we've had a few cases where someone is, addicted to drugs or alcohol, and we need to take steps to protect them because of the dementia as a result of long-time alcohol or drug abuse. So when those petitions are filed and that attorney goes out, then we have the examining committee go out and meet with the person, and they'll run the person through a number of exams, usually mini mental status exams or something like that. And then they will make an assessment as to what types of rights need to be removed, and they will file a report with the court. And then we have an incapacity hearing. And at that hearing, the alleged incapacitated person can come in, they can hear what's going on, they can make objections, they can hire their own examining committee or examiner, and sometimes it can be protracted litigation. Most of the time it's not. Most of the time it's pretty pro forma, because most of our alleged incapacitated people really do need help, and they really do want help. They just aren't sure how to do it, and we create a system for that help. Now, as I said, sometimes people come in with durable powers of attorney and that sort of thing, or trust instruments. And so sometimes what we just need the judge to do is to enter an order of incapacity so that the person understands that they're no longer capable of being their own trustee or managing their own finances. And then the judge will appoint that agent under power of attorney as the less restrictive alternative. And that allows us to move forward with the proceedings. So, in a nutshell, that's a guardianship proceeding. The judge will enter orders at that point, appointing the guardian, and sometimes there's some debate as to who the guardian should be, but we'll save that for a different video because it's getting pretty long. And then, we start the process of administering the guardianship, which does require an attorney. We file petitions with the court to set up depositories for the guardianship assets, and then as expenditures are needed, then we ask the court's permission for those expenditures. And each year there's an annual accounting, there's an annual plan that has to be filed. As you can see, it's pretty expensive to do these kinds of cases, but sometimes necessary. And that, in a nutshell, is what happens in a guardianship proceeding. I look forward to talking to you at our call, and if you have any questions, don't hesitate to shoot us an email or give us a call. My name is Shannon Miller. I'm with the Miller Elder Law Firm.